మనం నిన్న నేర్చుకున్న కాన్సెప్ట్సే fair wages repeated 3 times. Yesterday's question was more about before Whitley's commission. Oh, it will be in 1 minute. Can you guys see it?
Yes.
Yeah. So yeah, question 4, we have learned about minimum fair and living wages. In question 8, it's only talking about fair wages. So you have to write about fair wages. So basically, you have to remember one thing, that minimum wages, fair wages, and living wages. So fair wages are in between minimum wages and living wages. So fair wages is a concept that sits between minimum wage and living wage. So minimum wage is a legally mandated lowest possible wage, and living wage is a way sufficient to provide a decent standard of living. So it represents a level of remuneration that is just and equitable for both the employee and employer, taking into account various economic and social factors. So what are the key characteristics of a fair wage? So it says it's more than subsistence. It goes beyond merely covering the basic physiological needs of a worker and aims to provide for a degree of comfort and well-being. So considers capacity to pay. Unlike the living wage, which focuses primarily on the needs of the worker, the fair wage takes into account the employee's ability to pay without jeopardizing the economic viability of the establishment. So important thing ఏంటంటే అసలు living wages is like ideal, but fair wages లో employee అసలు ఇవ్వగలడా అని చూసుకుని fair wages define చేస్తారు, one of the key things, and reflects productivity. The productivity of a worker and the industry overall efficiency are considered relevant factors in determining a fair wage. So what are the prevailing rates? The wage rates for similar occupation in the same industry and the region serve as an important benchmark. For example, like somebody working in a chemical factory in Bombay might get paid more to compare to a guy who's working in a chemical factory in Vijayawada or in a two-tier city or Kadapa or someplace. Okay, and then the cost of living, well, not the sole determinant. The cost of living in a particular area is a factor in assessing the fare of a wage. So cost of living అంటే అక్కడ ఎంత అవుతుంది to live, rent ki, wheat ki, వాటికి కూరగాయలు, all that cost of living, how much, and then you factor that into the fair wage. And the fourth one is level of national income and its distribution. The overall economic context and distribution of wealth in the country can influence what is considered as a fair wage. So national economic distributions kuda they take into consideration. Social justice. The concept embodies principles of fairness and equity in distribution of fruits of the labor. So basically fair wages, what are the key characteristics? How is it determined? So there are like 6 or 7 points which you have to remember for the exam. And then in the context of the new code of wages, does fair wages as a gurinchi asalu emana unda? The code of wages law ఏంటంటే 2019 consolidates a lot of laws, which is basically, we know that the wages, bonus and related matters in India. While the code primarily focuses on defining and regulating minimum wages, it also acknowledges the concept of fair wage and provides a framework that can facilitate its eventual realization. Here's how the code of wages relates to the concept of fair wages. First, you have to remember one thing, that below minimum wage, there is something called a floor wage. So hierarchy in a floor wage, minimum wage, fair wage, and then living wage. So you have to remember this hierarchy. So what happens is, as per the new code, the code empowers the central government to fix a floor wage, taking into account the minimum living standards. The floor wage acts as a base below which minimum wage cannot be set by any state government. So ఏం చేస్తుందంటే, the central government fixes a floor wage, and based on the, like Maharashtra minimum wages might be, the floor wage might be 50 rupees. Maharashtra says, okay, minimum wage will be 100 rupees. Whereas Manipur or a hilly area might say the floor wage is only 80 rupees. So floor wage meeda states have the liberty to set the minimum wages. While not explicitly termed, the floor wage aims to ensure the basic living. So basically, floor wage anedi central government is a subsistence living where minimum living standards are met. And then section fixation of minimum wages, section 6 and 8. when fixing minimum wages, appropriate government is mandated to consider factors such as prevailing wage rates or for similar occupation, the circumstances of the employment and the need of workers having regard to the capacity of scheduled employment to pay. This consideration of industry capacity aligns with one of the key tenets of fair wage. So what they're saying is, when they're trying to fix the minimum wages, they are seeing that whether the prevalent wage rates ఒకటి across industry same ఉన్నాయా లేదా, and then the propensity to pay by the employer. అసలు ఎంప్లాయర్ ఇంత పే చేయగలడా లేదా, అంటే ఈ ఈ ఇండస్ట్రీలో వేఫర్ థిన్ మార్జిన్స్ ఉన్నప్పుడు మినిమం వేజెస్ వీళ్ళు ఎంత పే చేయగలరా లేదా అనేది దే టేక్ ఇట్ టు కన్సిడరేషన్, విచ్ ఇస్ సిమిలర్ టు వాట్ వీఆర్ టాకింగ్ ఇన్ ద ఫేర్ వేజ్, వేర్ వీఆర్ సేయింగ్ దట్ they take into consideration whether the employer can pay without jeopardizing the economic viability of the establishment. And also the fair wages is also mentioned in advisory boards, which is section 42. The code for constitution of central and state advisory boards comprises representatives, employees and independent person. The board advises the respective governments on matters related to fixation and revision of minimum wages and other wages related to the issue, included in the broader principles of fair wages. Potential for future evolution. While the code doesn't directly mandate the implementation of fair wages, this is important. The code never directly mandates implementation of fair wages across all sectors. It only talks about minimum wages and the factors that are basically considering economic factors and tripartite consultants creating a pathway for fair wages. And it is showing a pathway for fair wages, కానీ it never says that implementation ఇలా జరగాలని చెప్పదు. And it only focuses on minimum standards. The code primarily ensures a basic minimum wage for all workers. However, by establishing a floor wage and requiring consideration of industry capacity, it implicitly acknowledges the need to move beyond subsistence towards fair levels of compensation. So in essence, the code of wages establishes a minimum wage, which is based upon the fair wages can be built, and mandates consideration of factors such as or determining fair, which such as industry capacity, prevailing rates during the fixation of minimum wages. I think the way you have to look at it is, what they're trying to say is, if floor wages are the minimum wages, then minimum wages which this code is saying is more or less equivalent to the fair wages. So that's where they're, I think, leading into, but the code has not specified anywhere about the fair wages etla calculate cheyalanedi లేదు. Okay, so these are the two cases. The first case is worksman represented by secretary versus management of this one. The Supreme Court elaborated the concept of fair wage, holding that the fair wage should enable the worker to maintain not just physical efficiency, but also the level of education, minimum requirements, and some amenities. The court emphasized that fair wages must keep pace with increasing national income and cost of living, bonus allowances. So basically, in India, this was a case where the Supreme Court talked about the concept of fair wage, and it also gave how do we calculate the fair wage, and what are the factors that need to be taken into consideration when calculating a fair wage. So basically, this was the first case where wages గురించి ఫైట్ అయినప్పుడు సోషియో ఎకనామిక్ కండిషన్స్ అంటారు. ఆ సోషియో ఎకనామిక్ కండిషన్స్ ని ఫస్ట్ టైం ద సుప్రీం కోర్ట్ సెడ్ సోషియో ఎకనామిక్ కండిషన్ షుడ్ బి ఫ్యాక్టర్డ్ ఇంటూ when you are calculating the wages, and it can be called as fair wages. ఆ సోషియో ఎకనామిక్ కండిషన్స్ లో ఎడ్యుకేషన్, మెడికల్ రిక్వైర్మెంట్స్ అండ్ అదర్ ఎమ్యూనిటీస్ యాడ్ చేశారు అనమాట. బేసికలీ there are 6 things which they have added specifically, and they're given the percentages also. In the 25% of these, 50% of these అని అలా రాశారు. నాకు ఎగ్జాక్ట్ గా గుర్తులేదు, బట్ this was and this is where this case is quoted everywhere. Like whenever they talk about committees about setting up minimum wages, you take any report which they do, they quote these cases saying that this case the Supreme Court has already said how to do fair wages, and these socio-economic conditions మీరు factor చేయాలి. Okay. The court emphasizes the fair wage must keep pace with increasing national income and cost of living. Bonus allowances and other benefits must be adjusted to maintain fairness, considering profitability and capacity of employer to pay. excuse me. The second case which we are talking about is Kamani Metals versus and Alloys versus their workmen. Anybody remember what this case was about in the past? ఉన్నారా వెళ్ళిపోయారా అసలు? Okay, this was a case where we were talking about set on and set off.
Yes, correct.
Yeah,
In the bonus kada?
Bonus
concept.
Perfect,
Yes.
madam. So this is also a landmark case. In this case, the court affirmed the fair wages must balance the interests of both employees and employers. The judgment linked fair wages principle to profitability. అంటే ఈ కేసు బేసికలీ ఆ ఫేర్ వేజెస్ సెట్ ఆన్ సెట్ ఆఫ్ గురించి మాట్లాడుతూ ఫేర్ వేజెస్ కూడా చెప్పింది. సో వీ హావ్ కోటెడ్ అగైన్ ఇన్ ద ఫేర్ వేజెస్. మీ ఫేర్ వేజెస్ క్వశ్చన్ వచ్చినప్పుడు ఇది కూడా కోట్ చేయొచ్చు. అండ్ యూ కెన్ ఆల్సో టాక్ అబౌట్ సెట్ ఆన్ అండ్ సెట్ ఆఫ్ హియర్. ఓకే, ఇందులో ఏంటంటే the two key aspects of this case is one is the surplus లో set on set off ఎట్లా చేయాలి bonuses కి. Second thing lo what they have said is fair wage principles linked to profitability, recognizing that the fluctuations in profit should not unduly deprive workers of their fair economic share over a sustained period. Okay. And while the code doesn't explicitly mandate fair wage implementation across the board, it provisions for minimum wages setting, that is broader framework acknowledging the importance of considering factors that contribute to the fair compensation for workers. The establishment of robust and effectively enforced wage system is often seen as crucial step towards achieving the broader goal of fair wages for all. This is about fair wages. Any questions? Okay, we'll move to the next one. The next one is basically allocable surplus. So this is also asked 3 times. So చాలా మంది క్వశ్చన్ లో ఇంట్రెస్టింగ్ ప్రాబ్లం ఏంటంటే allocable surplus గురించి రాయగా available surplus గురించి రాస్తారు. So you have to understand all the key concepts that go on how do we calculate the allocable surplus. So allocable surplus is a statutory defined share of profit that employees are required to allocate for employees to be entitled for the payment of bonus. Allocable surplus is derived from available surplus, which takes gross profits and deducts certain chargeable expenses. The allocation of surplus was introduced under Code of Wages 2019. Supersedes the payment of bonus, and to ensure fairness in allocation profits and to acknowledge employees as stakeholders in the success of an enterprise. These highlights the policy of inclusive growth, which encompasses growth in the workplace as well. So what are the provisions? Legal provisions, section 31, allocation rates. First of all, manakunna appudu kotta section 2019 Code of Wages lo allocable surplus అసలు ఎంత ఉండాలి, అదేం చేశారంటే బ్యాంకింగ్ కంపెనీస్, ఫర్ ఎగ్జాంపుల్ ఎస్బీఐ అండ్ అదర్ బ్యాంక్స్, యూనియన్ బ్యాంక్, ఆల్ దీస్ బ్యాంక్స్ ఉన్నారు. ఇఫ్ ద బ్యాంక్ మేక్స్ ప్రాఫిట్స్ అండ్ ఇఫ్ దే హ్యావ్ అవైలబుల్ సర్ప్లస్ ఆఫ్టర్ ఆల్ ద క్యాల్కులేషన్స్, 60% ఆఫ్ ద అవైలబుల్ సర్ప్లస్ ఇన్ ఎస్బీఐ విల్ బి allocable surplus. ఆ allocable surplus లోంచి మళ్ళీ మినిమం 8.33% will be given to each person of the salary. 8.33% of the annual salary వాళ్ళకి బోనస్ గా ఇవ్వాలి మినిమం. సో అదర్ ఎస్టాబ్లిష్మెంట్స్ allocable surplus is 67%. సో ఫర్ ఎగ్జాంపుల్ ఇండియన్ ఆయిల్ ఉంది, ఆర్ బీడిఎల్ ఉంది, ఆర్ సమ్ అదర్ కంపెనీ ఉంది which are run by governments mostly, which is basically where they're saying that the allocation is intended to ensure the fair portion of real profits. Or even in private companies, they are saying that this is what it should be allocated towards employee, towards bonus of major industries including manufacturing, services and others. So what is available surplus? So what we are saying is allocable surplus available surplus నుంచి వచ్చింది అని 60% or 67%. So what is available surplus? Idi again section 33 says available surplus is a net real profit after deducting prescribed statutory deductions as prescribed in section 34. So section 34 లో gross profit minus deductions అని ఒకటి ఉంటుంది. So 33 only says available surplus అంటే gross profits minus deductions. Deductions అంటే ఏంటి మళ్ళీ section 34 లో డిఫైన్ చేశారు. So section 34 లో what are the deductions? There are basically, you have to remember the 4 deductions. One is depreciation. So let's say we buy 100 crores worth of machinery. It is depreciated in 10 years as per the depreciation schedule. So 10 years under 10 crores every year. So gross profits minus our 10 crores helpotadi. That's the first thing. And then they also need to deduct wear and tear of the capital asset before the surplus is calculated. So in the wear and tear, ఇప్పుడు machines 100 కోట్లు పెట్టుకున్నాం, దానికి wear and tear మెయింటెనెన్స్ ఒక 2-3 కోట్లు అయింది, అది కూడా డిడక్ట్ చేయాలి. Next to direct taxes. So whatever corporate tax is there, gross profits minus whatever gross profits enta the tax kattalo based on the income tax, you have to deduct those direct taxes. The third one is return on capital employed. So for example, మనము ఈ కంపెనీ పెట్టడానికి 200 crores అయింది. 200 crores అయితే, so annually the old model said 6% of the return of capital, 200 మీద 6%. which is basically annually 12 crores gross profit minus that 12 crores you can remove. But in the new code, it doesn't prescribe the percentage. In the old code, it was 6%. So the return on paid up capital is calculated at the rate prescribed by the Reserve Bank of India. So I think every year the RBI prescribes how much we can deduct to give the available surplus. Okay, and then the other one is return on reserves. When an employee utilizes internal reserves as working capital, an allowable return is deductible. So working capital మనకి 10 crores అయింది, మనము షర్ట్స్. So sorry, you have a question?
No, in between I lost your voice.
Okay.
Yeah.
ఇప్పుడు వచ్చిందా సార్?
ఇప్పుడు fine, sir.
Okay. So sorry, what I was saying is return on reserves అంటే basically working capital. Either మనం usually typically companies borrow working capital from a bank. Like నాకు 10 crores working capital కావాలి సార్, నేను రా మెటీరియల్ కొనుక్కోవడానికి. 10% మీద బ్యాంకులు what they do, they put interest కదా. So let's say if the employer has his own reserves, if the employee utilizes his own internal reserves of working capital, దాని మీద ఇంట్రెస్ట్ ఏదైతే బ్యాంక్ ఇచ్చే ఇంట్రెస్ట్ కూడా ఎంప్లాయర్కి ఇస్తారనమాట. అండ్ దిస్ రేట్ ఈస్ ప్రిస్క్రైబ్ బై ద రూల్ ఆఫ్ ద సెంట్రల్ గవర్నమెంట్. సో దీస్ ఆర్ ద 4 areas which you have to remember. Allocable surplus is got from available surplus. Available surplus, gross profits minus these deduction, depreciation, taxes, return on capital employed, and return on reserves. These are the 4 areas where you get the all the deductions, and then gross profit minus cheste you get available surplus. This is the same thing which is repeating again, which is basically how do you calculate the gross profits, income from operations and investments and other income, all the incomes you take, and then you subtract depreciation, taxes, return on capital, and return on reserves. Okay, and then available surplus is basically available surplus is basically net profits after all deductions. And then allocable surplus also the allocable surplus 60% of banking and 67% of all others. So this equals allocable surplus. So in this also, this is the amount of money that is legal for bonus pool, where employees must earn a minimum of 8.33 and up to 20% of their salary depending on the profitability. So minimum 8.33 ఇవ్వాలి and maximum 20% ఇవ్వాలి. నిన్న పవన్ సార్ అన్నట్టు 8.33 is nothing but 1 month of salary. And 20% might be approximately 8 into 3 కాబట్టి 2.5 months of salary. అంతే కదా సార్?
అంతే సార్.
Yeah. So what are the cases in this which we can quote is basically, this case is also very famous case, Moyer Mills versus Worksman. ఈ కేసులో ఏంటంటే ఏదైతే మనం ఇందాక పైన అంతా చదివామో, this case defined and clarified the distance between gross profits available surplus and allocable surplus. Okay, so that's why this case is important. And of course, this case came in 1960. So the new code has come. This is a leading precedent directly related to the bonus and allocable surplus under the payment of bonus tax, which is now integrated into the Code of Wages 2019. The second one is basically Kamani Metals and Alloy versus workmen. This case dealt with the payment of fair wages and minimum bonus. Reinforced that bonus is not solely. Is this the earlier case which we were talking about? Yeah.
The same case, sir.
Same case. Set on and set off JSL.
Yes.
So we are quoting the same case again. Okay. If basically this case, Kamani Metals kuda manchi case andi. Fair wages గురించి మాట్లాడింది, మినిమం బోనస్ గురించి మాట్లాడింది, సెట్ ఆన్ సెట్ ఆఫ్ ఎలా చేయాలి కూడా మాట్లాడింది. And whatever cases I'm listing here are basically Supreme Court cases. I am not taking any district cases or High Court cases, because one of the things which like in the law firm where I'm sitting, one of the good things which Rajiv was talking about, he said, is what is the highest authority of a legal case, which is basically Supreme Court, right? So he's saying wherever possible, try to learn a lot of Supreme Court cases, which will help you in your arguments as well as when you're drafting the case. Because Supreme Court paina inka ledhu kada authority. So if you can find similar cases in Supreme Court, that means that you have solved half of your problem. Okay, I hope you are listening, or
No, we are listening.
Yes, sir. Yeah.
Okay. Yeah. So అందుకని ఏం చేశానంటే I've started quoting all Supreme Court landmark cases, which are also helpful for the, and even I think the examiner or the writer guy who is correcting will also understand the cases because these are landmark cases. Okay. And then practical significance and workers protection in India to protect workers' right to ensure remuneration, demand compliance from other businesses, stop business from exploiting the surplus, promote harmonious and equitable industrial relations. Conclusion and allocable surplus considers in Code of Wages retain and advance the thread of labor laws in India, building the case laws regarding profit sharing and altruism through legal deductions and allocation. So the code is defined and enforceable formula for bonus calculations. So case laws basically are Supreme Court has built common law basis for the employees and to demand legitimate claims to a surplus of profit. So this is judicial activism or overreach. Activism antaru madam. Okay. All right.
Sadhu, I have a question.
Yes.
So Code of Wages 2019 says that bonus is, if my understanding is right, it says that the bonus should be dependent on what is available as allocable surplus. Am I right?
Yeah. Ante Code of Wages 2019 law, the problem there is they have not defined on the bonus. But if you are paying bonus, ante paata dantlo bonus undi. 2019 lo bonus gurinchi ekkada maatladaledu vaadu. But what they are saying is, if you are giving bonus 8.33% ఇవ్వాలి and bonus, then ఈ allocable surplus లో ఇవన్నీ calculate చేసి this is the formula.
Yeah, that's what I'm saying. So if you have, once you arrive at an allocable surplus, then you have to give a percentage of that as bonus, 8.33 or whatever, right?
220. Yeah, sorry, Chapman.
So in this case, Kamani Metals and Alloys Limited and versus the work firm, which was fought in 1967, it has a very different and interesting judgment. It said minimum bonus is pretty much statutory, irrespective of allocable surplus.
Correct. Appudu vallu, they are saying entitled to minimum bonus regardless of allocable surplus. In
Correct.
this aligning with the social justice objectives of the bonus law అని కూడా చెప్పారు.
That's what I'm saying. Code of Wages 2019 has overwritten this principle then.
Yeah, yeah.
ఫిక్స్డ్
In a
అలోకబుల్ సర్ప్లస్ ఉంటే ఇవ్వండి అని కదా, అలోకబుల్
అంతే.
సర్ప్లస్ క్యాలిక్యులేట్ చేసి ఇవ్వండి అని. ఓకే,
ఇవ్వండి అని
don't-
కూడా అనలేదు వాళ్ళు. వాళ్ళు ఎంత స్మార్ట్ గా రాశారంటే ఇవ్వండి అని కూడా
అసలు
అనలేదు.
అది స్టాట్యుటరీ ఆబ్లిగేషనే కాదు ఇప్పుడు,
ఇప్పుడు ఆబ్లిగేషన్ కాదు. ఎగ్జాక్ట్లీ.
విచ్ ఇస్ వర్స్ యాక్చువల్లీ.
Yeah.
ఓకే
ఓకే మేడం.
Yeah.
సో
But in other countries, most of the in Middle East and some Europe countries, it is mandatory. 1 month salary is mandatory as bonus. Like in Middle East, before Ramzan vacation starts, they give 1 month salary as a bonus. That is a standard for any company, and it is a statutory.
బట్ యుఎస్ లో, యూరోప్ లో లేదు సార్.
యూరోప్ లో కూడా కొన్ని కంట్రీస్ లో ఉంది సార్.
బట్ అంటే bonus is not mandatory. I think they've just followed the Western this thing, because the Western companies ఇక్కడ రావడానికి they asked for some amendments which they made.
Okay.
Okay. Sir, question 10 inches. Can somebody read, please?
Yeah. I'll go through.
Okay, sir. Yeah.
I can also read.
Arey wow. Mali madam is it?
That don't call me ma'am, please. Just call me ma'am.
How are you feeling?
Yeah, I'm fine. I can read, but if somebody can add on, it will be nice.
Please start, madam. Yeah.
Okay. Because I didn't read this labor only since 1 week. I was not very this fun. Okay. Question number 10, equal remuneration. 3 times it was repeated. Equal remuneration and equal pay for equal work are fundamental. I'm starting. Okay, no?
Yeah, go ahead. Go ahead. Yeah.
Okay. Equal remuneration and equal pay for equal work are fundamental principles advocating that individuals should receive the same pay for performing the same work or work of a similar nature regardless of their gender. This concept lies at the heart of ensuring gender equality and eliminating economic discrimination against women in the workplace. Okay, what is the principle? The core idea is that value of work should be determined by objective factors like skill, effort, responsibility, and working conditions without considering gender of the person performing the job. Okay, it aims to dismantle the historical and societal bias that have often led women to being paid less than men for same or equally valuable work. So it should be determined based on objective factors like skill, effort, responsibility, and working conditions. That is the core principle of this equal remuneration, equal pay for equal work. Equal Remuneration Act 1976, key legislation in India enacted to give effect to the principle of equal pay for equal work, particularly concerning gender. Key aspects of Equal Remuneration Act 1976. Objective is to provide for the payment of equal remuneration to men and women for the same work or work of similar nature. Same thing we have read it before, and to prevent discrimination based on sex in matters of employment. Duty of the employer, Section 4. This is the central provision. Central provision. Duty of the employer, Section 4 is the central provision mandating that employers must pay equal remuneration to male and female workers for the same work or work of similar nature. It also prohibits the employers from reducing the wage rate of any worker to comply with this provision. The aim is to equalize and cure the disparities that exist in the wages of men and women. Men and women, definition of same work or work of a similar nature. Is it another line? The aim is to equalize and cure the disparities that exist in the wages of men and women. So definition of same work or work of similar nature. Oh, so definition of same work or work of similar nature is given in section 2H. This act defines this crucial term as work where the skill, effort, and responsibility required are the same and performed under similar working conditions by a man or a woman. This extends beyond identical job titles to encompass roles of a comparable value. No discrimination in recruitment. Section 5. Employers are prohibited from making any discrimination against women in recruitment. During the terms and conditions of employment for the same work or work of similar nature, except where the employment of women is restricted by law. So there are some exceptions. Okay. Overriding effect. Overriding effect, section 3. The Act has an overriding effect over any other law, contract, or agreement that is inconsistent with its provisions. This ensures that the principle of equal remuneration takes precedence. What is this overriding effect? Overriding effect. This Act has an overriding effect over any other law, contract, or agreement that is inconsistent with its provisions. Okay, this ensures the principle of equal remuneration takes precedence. Advisory Committee, Section 6. This Act provides for the constitution of an advisory committee to advise the government on matters related to increasing employment opportunities for women. Authorities for hearing claims, Section 7. The appropriate government is empowered to appoint authorities to hear and decide the complaints regarding the contravention of the Act and claims for equal remuneration. Inspectors is given Section 9. The Act provides for appointment of inspectors to investigate compliance with its provisions. Penalties. Section 10. Employers who violate the provisions of the Act are liable for fines and imprisonment. Significance and interrelation. The Equal Remuneration Act 1976 is the legal embodiment of the principle of equal remuneration or equal pay for equal work in India. It provides a legal framework to address gender-based wage discrimination and ensures that women have a statutory right to claim for equal pay for work of equal value and reinforces constitutional values under Article 14, 15, and 16. Principle is equal remuneration, equal pay for equal work. Constitutional values are 14, 15, and 16. In essence, understanding the Equal Remuneration Act 1976 is essential to grasping the legal mechanisms in place to promote and enforce fundamental right to equal pay for equal work in context of gender equality in India. Okay. Relevant cases are Randhir Singh. Randhir Singh is that constable driver. Constable something. Is it the same case?
That's
same
right.
This is the same
Delhi
case.
driver.
Okay. Delhi driver. Delhi driver. Kani,
Yes.
it's related to women, no? How this? Okay, maybe it's equal pay for equal work. Okay. Randhir
This
Singh versus
is
Union of India. Supreme Court held that equal pay for equal work is a constitutional guarantee under Article 14 and 16. The court ruled that arbitrary classification among employees performing similar duties amounts to violation of equality principles. Even in the absence of statutory rules, the principle must guide the actions of the state as an employer.
Take this,
What happened?
Yep, I think Pawan is talking. Okay. Sorry, I muted him. Chappan. Yeah.
Shall I continue?
Yeah. No, he
Okay.
was talking with his spouse, I guess. Yeah.
Acha, okay. Okay, so relevant cases is Randhir Singh versus Union of India. This case is based on equal pay for equal work. Court said that arbitrary classification among employees performing similar duties amounts to violation of equality principles. What is the key point here is equal pay is not just a moral obligation but a constitutional mandate under Article 14 and 16. Okay, enforceable by the courts. Then DS Nakara versus Union of India. Although primarily about pensioners' rights, the court in this case reaffirmed that economic benefits, including wages, must be distributed fairly and equitably without arbitrary classifications. It reaffirmed that social justice and economic equality are inherent in interpreting labor welfare legislations like the Equal Remuneration Act. Key point is fairness in wage distribution is crucial to achieving economic justice, a constitutional goal. Sir, the thing is, context of gender equality అని మన వేరే టైప్ కేసెస్ రాస్తున్నాం కదా పర్వాలేదా
ఇది
అంటే
equal.
ఫస్ట్
The question is about equal remuneration.
కానీ ఎవ్రీవేర్ ఇట్ ఈస్ గివెన్ ఫర్ విమెన్ దిస్ దాట్ అండ్ ఆల్ కానీ
Yeah. No,
కేస్ లాస్ మన పర్వాలేదా ఇట్లా ఐ మీన్ వీ కెన్ రైట్ ద ఫస్ట్
That is
కేస్ ఐ థింక్
part B లో మనకు ఒక question, last question we got it, sir. I think that is that case is more relevant here. అంటే women gender parity కోసం అని చెప్తే
అంటే
McKinnon and McKinsey female stenographer and male stenographer parity వచ్చింది చూడండి. I mean, when it comes to only the gender parity.
So gender parity is just one issue in equal remuneration.
Yes.
So similar work situations undi ఇద్దరికి సేమ్ సాలరీ రావట్లేదు అనుకోండి, that is also equal remuneration problem. Women and men ki equal ga raatలేదు, that's what we have written, right?
Okay,
Same
okay.
work.
Two men also in working in different. That is Randhir Singh. So like Randhir Singh.
Yeah,
Correct.
Same work for okay. And another problem is between men and women.
Gender equality. Yeah.
So rendu context వస్తాయి.
And this DS Nakara Union of India ఏంటంటే పే స్కేల్ ఏవైతే వీళ్ళు కమిషన్స్ మార్చినప్పుడు వాళ్ళు ఏం చేశారు, పెన్షనర్స్ కి తీసేశారు. అంటే లైక్ సెంట్రల్ గవర్నమెంట్ పే స్కేల్స్ వస్తాయి కదా, వాళ్ళు రివిజన్స్ వస్తాయి. రివిజన్స్ వచ్చినప్పుడు పెన్షనర్స్ పట్టించుకోలేదు. అందుకని 1983లో ఆయన వెళ్ళి కేసు వేసాడు. అంటే పెన్షనర్స్ వదిలేసారా మీరు, వాళ్ళకి ఇచ్చినప్పుడు ఆ పే స్కేల్స్ లో మాకు కూడా ఇంక్రీజ్ అవ్వాలి కదా అని.
ఓకే.
So there is a discrimination of pensioners also. Equal remuneration of pensioners also. Yeah, so there are multiple
sections are there. Okay.
there are multiple facets to the problem. Yeah.
Okay. So it's not only gender equality. Fine. Sorry. So
Yes.
shall I go to question 11? Child labor.
Yeah.
Child labor. Question 11, child labor repeated 3 times. Child labor refers to the employment of children in any work that deprives them of their childhood, their right to education, and their physical and mental well-being. It is a serious social issue with long-term consequences for individuals and society. The Child Labor Prohibition and Regulation Act 1986 was a significant piece of legislation in India aimed at addressing this problem. Primary objectives are to prohibit the engagement of children defined as those who have not completed their 14th year. Okay. Child ante who has not completed their 14th year in certain hazardous occupations and processes. Ante to prohibit the engagement of children in certain hazardous occupations and processes. These occupations and processes were listed in the schedule to the act and included industries like mining, match factories, and construction work. There was a very famous case, I think, Tamil Nadu case ఏదో ఉండేది, match factory ఏదో, I don't remember.
Yeah,
Okay.
Shivakasi case.
Yes, ma'am. Yes. It was match factory కదా, matches ఏదో నాకు
Fireworks.
గుర్తులేదు. Fireworks. Yes. Correct. అవునవును, ఎక్కడో న్యూస్ పేపర్లోనో ఎక్కడో చదివాను. ఓకే.
Last time lo చదివారు. Go ahead.
Oh, last time. Okay.
Last
Okay,
time
fine.
long questions లో కూడా చదివా.
లేబర్ లాలో కూడా చదివాం అది.
నాకు అసలు గుర్తులేదు. ఓకే, ఫైన్. The child labor prohibition, so fine. This primary objectives ఏంటంటే to prohibit the engagement of children in certain hazardous occupations and processes. Then to regulate the conditions of work of children in certain other hazardous employments where they were not prohibited from working. This included setting limits on working hours, rest intervals, ensuring safe and healthy working conditions. Key provisions of the Act. Prohibition of employment. Section 3 of the Act prohibits the employment of children in occupations and processes listed in Part A and B of the schedule. However, there is an exception. This prohibition does not apply to any workshop where work is carried on by the occupier with aid of their family. Okay. Or to any school that is established by or is receiving assistance or recognition from the government. అంటే ఇది ఏంటి, దట్ స్కిల్ బేస్డ్ టైప్ స్కూల్స్ ఏమైనా ఉంటాయా, సంథింగ్ లైక్ దట్ ప్రాబ్లీ. అండ్ సంథింగ్ ఐ థింక్ ద ఫ్యామిలీ ఆల్సో ఇస్ ఫ్యామిలీ
అట్లా
టైప్
కాదు,
వర్క్.
అంటే if the teacher says clean up your classroom
ఓకే.
before the class starts, you cannot consider that as child labor.
ఓ అవునా మేడం? అంటే ఆబ్వియస్లీ ఇట్ విల్ బి అ గవర్నమెంట్ స్కూల్. ప్రైవేట్ స్కూల్స్ లో అట్లా చెప్తే చంపుతారేమో.
ప్రైవేట్ స్కూల్స్ లో అట్లా చెప్పని కూడా చెప్పర్లే, బేసిక్ ఇది. బట్
పేరెంట్స్ ఓన్లీ విల్ కమ్ రన్నింగ్ అండ్ టెల్ no and all.
No, actually శ్లోక స్కూల్లో దే మేక్ యూ క్లీన్ ద ఎంటైర్ క్లాస్. వెళ్ళేటప్పుడు కూడా ఊడ్చి పంపిస్తారు స్కూల్.
Really? My
Yeah, even
God.
kinder kids do that. Yeah.
Only మంచిదే.
They will learn how to do their own work then.
Yeah, so important. Okay. Key provisions of the Act is prohibition of employment. I told this. Then regulation of working conditions. Part 3 of the Act, Section 6 to 12, dealt with the regulation of the conditions of work for children in permitted employments. These provisions include limited period of work, limiting the working hours to a prescribed number with a mandatory rest interval of at least 1 hour after every 3 hours of work. The total working hours, including rest, should not exceed 6 hours a day. Night work between 7 to 8, 7 p.m. and 8 a.m. and overtime work were prohibited, because the children know. Weekly holidays, every child was entitled to one whole day of
One thing,
holiday each week.
Hemali, I mean, sorry to stop you.
No problem.
Ikkada, before beginning this answering this question, we have to clearly understand that any child below 14 years, there's
Mm.
complete no for work. This section which you are reading, where they can do, where all these conditions have to prevail, this is for 14 to 18-year-old children. Okay.
Oh, okay.
First, అది
14
రాయాలి
to 18.
answer లో what is child labor, who is considered a child labor, and there are two sections. One is anyone employed below 14 years of age is considered a child labor. So that is a
Okay.
no thing. Then 14 to 18 they can, yeah, sorry.
No, go ahead, man. Go ahead. Yeah.
So 14 to 18 they can be employed, but in non-hazardous industries. That's all.
Mm.
Or
14 to
facilities.
18 are called adolescent. అందుకనే నేను ఈ
Adolescent.
usually question పైన if you see after the repeat I say see long question 4. That means that it is already we have studied this in question 4.
Okay.
ఇక్కడ రాశారు సి లాంగ్ క్వశ్చన్ 4 అని.
ఇక్కడ ఉంది మేడం, రిపీట్ తర్వాత
Question
ఇయర్స్
11
తర్వాత
తర్వాత
సి లాంగ్
ఉందమ్మా.
క్వశ్చన్ 4 ఉంది.
ఇది చాలా సైంటిఫిక్ రిసర్చ్ చేసి నోట్స్ తయారు చేసాం మేము. ఓకే.
Okay.
Too good, sir.
Ma'am, you want to say anything else?
No, that's it. I just wanted to say that so we are not getting confused here. That's all.
No, that's true. Okay. Sir, you want to say anything or shall I continue?
No, I think that is an important point that we have to define what child labor is, right? Like madam చెప్పారు కదా. So 14 years గుర్తుంచుకోవాలి and adolescent అంటారు 14 to 18 years.
14 to 18 is adolescent. అవును, అదైతే కరెక్ట్.
And then there is a prevention of employees of adolescents in hazardous occupations. So అవన్నీ వస్తాయి which question 4 లో ఉన్నాయి. మీరు అవి చూసి కొంచెం అది basically my understanding is if you are reading any notes go with first part B. Part B మీరు 11 questions నేర్చుకున్నారంటే part A లో చాలా repeats ఉంటాయి. So here we are assuming that you already know that
Already
long.
read. Okay.
So some highlights లాగా పెట్టాం ఇక్కడ.
Okay. Sorry.
Yeah, go ahead.
Okay. Regulation of working conditions. Part 3 of the Act, Section 6 to 12, dealt with the regulation of conditions of work for children in permitted employments. These provisions included limited period of work. Okay, that I already read. Then weekly holidays, health and safety. Appropriate government is empowered to make rules for health and safety of children employed in establishments. Notice to the inspector. Employers were required to give notice to the inspector of their intention to employ children. Maintenance of registers. Employers are obligated to maintain registers containing the details of the child employees, including their name, state of birth, working hours, nature of work, all those. Everything should be there in the register. Display of notices. Display of notices. Abstracts of section 3 and 14 of the Act were required to be displayed in a conspicuous place in the establishment. Abstracts of section 3 and 14. Okay, they prohibition of employment. Okay. 14 ఏంటి? ఇది 14. Penalties. Section 14 prescribes penalties for the contravention of the provisions of the Act. Employing a child in prohibited occupations or processes could lead to imprisonment for a term not less than 3 months, which could extend to 1 year, or with a fine not less than 10,000 rupees, which could extend to 20,000 rupees, or both. Additionally, repeat offenders face stricter penalties, including 6 months to 2 years of imprisonment. అసలు ఇంత గుర్తుంటుందా? Section 14 we can remember. Okay, age determination. Medical authorities were prescribed for granting certificates of age, which would be conclusive evidence of the child's age for the purposes of the Act. Advisory Committee. The Act provided for the constitution of a Child Labour Technical Advisory Committee to advise the central government on adding occupations and processes to the schedule. Significance and limitations. The Child Labour Prohibition and Regulation Act 1986 was a crucial step towards addressing child labour in India. Legally, it recognized the need to protect children from hazardous work and regulate their employment in non hazardous sectors. However, the Act had certain limitations. The distinction between prohibition and regulation allowed children to continue working in many non hazardous sectors, often under exploitative conditions. The exception for family based work led to significant number of children working in family enterprises, often in hazardous conditions without any legal protection. Enforcement of the act remained a significant challenge due to various socio-economic factors and the informal nature of child labor. Amendments and subsequent developments. Over time, there was increasing recognition of the need for a more comprehensive approach to eliminate all forms of child labor. This led to the Child and Adolescent Labor Prohibition and Regulation Amendment Act 2016, which brought about significant changes. What are the changes? Complete prohibition of child labor in all occupations and processes, with very limited exceptions. Children helping in family enterprises after school hours or during vacations, and child artists in certain entertainment industries under specific conditions. Okay. Prohibition of the employment of adolescents 14 to 18 years in hazardous occupations and processes. Stricter penalties for employing children and adolescents in the violation of the Act. Therefore, while Child Labour Prohibition Regulation Act 1986 was a landmark law, it has been significantly amended to strengthen the prohibition of child labour in India. Understanding this helps to provide a historical context. Okay. Protecting children from exploitation. Anybody wants to add anything?
Yeah, I think in the question 4, we have learned about the two cases. So the famous MC Mehta versus State of Tamil Nadu case, where the
Okay.
Supreme Court directed the formulation of rehabilitation of children working in the matches and fireworks.
Fireworks factory.
Are the children below 14 years hazardous? Article 24 of the Constitution violate చేస్తుంది అని చెప్పింది అన్నమాట.
Okay.
And the other case was basically one was about the age, the other was about PUDR, the People's Union of Democratic Rights versus Union of India. In that
Okay.
case, if you are making a child work for less than minimum wages, okay,
Mhm.
then it is
Okay.
called forced labor under Article 23.
Okay.
So
Forced labor. Okay.
So two things. ఒకటేమో below age and ఒకటి below minimum wages.
Mm-hmm. Okay.
If you want, you can quote them here, but it is important for the long question which might
Long
come in.
answers to read that once. Okay. Shall I go to the next one?
Yeah, go ahead.
Yes.
Okay. Question 12. Social insurance. 3 times repeated. Social insurance is a system where individuals are compelled, usually through legislation, to contribute to a common fund. So it's a system where individuals are compelled to contribute whereunto to common fund, which is then used to provide benefits and protection against various life risks and contingencies. The core principle is collective responsibility and risk pooling. Collective responsibility and risk pooling is the principle. Okay, benefits are typically related to contributions made, but the system also incorporates elements of social solidarity and redistribution.
So
The scope
one
of
of the sorry to interrupt, Himali.
no
See,
no
one of the important things is in the exam, they'll say social security or social insurance. So most of the people, what they do is social insurance kuda social security answer రాస్తారు. Social security is provided by the government. and there are multiple social security things which are there, right? Social insurance ఏంటంటే it is basically a common fund. Okay.
Okay.
So there is a difference. అంటే మనం కొంచెం ఇది కావాలని అలా అడుగుతారు మన ఎగ్జామ్ లో. సోషల్
Confused
ఇన్సూరెన్స్
ఉంది.
అంటే ఈ ఆన్సర్ రాయాలి మనం.
Okay.
Yeah, go
Social
ahead.
insurance.
Insurance వేరు, security వేరు. That's what I'm trying to say.
Security. Okay. Okay. Yeah. Yeah. Fine. So the scope of
According to
social.
me,
Yes,
sorry,
madam.
according to me, social security is a wider concept, whether it's provided by the government or whether it's provided by private establishment. Social insurance is particularly a fund.
Correct.
అదే ఇక్కడ
Exactly.
రాశారు మేడం నెక్స్ట్ లో. Relationship with social security, it's a significant component of broader concept of social security. Then మీరు చెప్పింది, I mean, సార్ కూడా అదే ఆర్ సార్ రాశారు మీరు చెప్పింది whatever. It's there in the next to this one. Okay, shall I read?
Go ahead. Yeah.
Okay. The scope of social insurance generally encompasses protection against old age, that is providing pensions and retirement benefits, sickness and covering healthcare costs, providing sick leave benefits, then disability, offering support and benefits to those unable to work due to disability, unemployment, providing temporary income support to those who have lost jobs, maternity, ensuring paid leave and benefits for pregnant and new mothers, work injury, compensating for injuries or illnesses sustained at work, survivorship, providing benefits to the dependents of deceased contributors. Okay, so all this comes under social insurance. Key characteristics of social insurance is compulsory participation. Often it is mandated by law for certain categories of population. Example, employees. Contributory financing. Funded through contributions from insured individuals, employers, and sometimes the government. Conditional benefits. Benefits are usually linked to contributions and fulfillment of eligibility criteria. Risk pooling means the risks are shared across a large group, providing protection against individual misfortunes. Social solidarity aims to provide a basic level of security to reduce inequality, often involving some degree of redistribution from higher to lower earners or from healthy to sick. Okay, government oversight, typically established, regulated, and often administered by the government or statutory bodies. What is the importance? Importance is first is economic security, provides a safety net against income loss due to various life events, ensuring a basic level of economic security for individuals and the families. Example, unemployment insurance, it helps the individuals to meet their basic needs while searching for a new job, thereby preventing them from falling into poverty. Then poverty reduction, by providing income support and access to essential services like healthcare, social insurance contributes significantly to reducing poverty and income inequality. Examples are old age pensions provide a regular income for senior citizens, preventing them from becoming dependent on others during their retirement years. Third is social stability, fosters social cohesion and reduces social unrest by providing a sense of security and shared responsibility within the community. People are more likely to accept economic changes and participate in the workforce, knowing that some protection exists during the difficult times. It provides social stability. Fourth is improved public health. Social health insurance schemes ensure access to medical care, leading to better health outcomes for the population, thereby reducing the financial burden of illness. For example, national health insurance programs allows the individuals to seek medical treatment without facing the catastrophic out-of-pocket expenses. Okay. Fifth is labor market efficiency. Unemployment insurance can facilitate a more efficient labor market by allowing the individuals to find suitable employment rather than being forced to take the first available job out of desperation. Okay, maternity benefits support the participation of women in the workplace. Sixth is economic development by fostering a healthy and secure workforce. Social insurance strengthens the overall economic productivity and development. Therefore, reduced poverty and improved health lead to a more engaged and productive citizenry. Dignity and social inclusion. Social insurance programs uphold the dignity of individuals. by providing providing them with a right to benefits based on their contributions and social membership, rather than solely relying on charity or means-tested assistance. Okay. Examples of social insurance schemes: Employee Provident Fund scheme in India. Employee Provident Fund undi, ESI undi. Okay, these are there in India, United States, Medicare in United States, unemployment insurance in many other countries, national health. Okay. So examples of social insurance schemes are EPF in India, mandatory saving schemes for retirement, where both employees and employers contribute. Employee state insurance scheme in India provides medical and other benefits to the employees in certain establishments funded by contributions. There's also contributions from both employer and employee. First is pensions, means retirement thing. Second is medical. Social security in United States funds insurance to the old age survivors and disability through taxes. Through payroll taxes. Okay. Medicare in United States, a federal health insurance program for those aged 65 or older and certain younger people with disabilities. Unemployment insurance in many other countries provides temporary income replacement to eligible unemployed workers. National health insurance system in various countries offers universal and near universal healthcare coverage funded through contributions and or taxes. Relationship with social security. So ఇక్కడ వచ్చిందన్నమాట social security and social insurance. Social insurance is a significant component of the broader concept of social security. Social security is a term that encompasses overall measures a society takes to protect its members from economic and social distress. Social insurance is one of the primary mechanisms used to achieve social security goals alongside other approaches like social assistance. It is non contributing, means tested. What is this means tested assistance, sir? And universal basic service. Means tested assistance.
What was it, Hemali?
Means tested benefits anta.
Benefits, okay. Social insurance, one of the primary
Means tested
mechanisms used to
assistance.
achieve social
నాకు
security goals.
అనిపిస్తుంది నేనే ఏదో
Non-
చదువుకుంటుంటా.
లేదు
కాదు ఇక్కడ సోషల్ ఇన్సూరెన్స్ ఇస్ వన్ ఆఫ్ ద ప్రైమరీ మెకానిజమ్స్ యూస్ టు అచీవ్ సోషల్ సెక్యూరిటీ గోల్స్ అలాంగ్ సైడ్ అదర్ అప్రోచెస్ లైక్ సోషల్ అసిస్టెన్స్. అంటే ఏంటి? నాన్ కాంట్రిబ్యూటరీ
సోషల్
మీన్స్
అసిస్టెన్స్ అంటే
టెస్టెడ్
నాన్
బెనిఫిట్స్.
కాంట్రిబ్యూటరీ. అట్లీస్ట్ నాన్ కాంట్రిబ్యూటరీ అంటే వేర్ ఇప్పుడు సపోజ్ అనార్గనైజ్ సెక్టర్ వర్కర్స్ ఉన్నారు, వెదర్ దే ఆర్ బిఓసిడబ్ల్యూ వర్కర్స్ ఆర్ కామన్ పెన్షనర్స్ ఇన్ ద విలేజర్స్, వాళ్ళేం కాంట్రిబ్యూట్ చేయరు దీనికి, గవర్నమెంట్ ప్రొవైడ్స్ దెమ్ కదా. సో ఇట్ ఈస్ నాన్ కాంట్రిబ్యూటరీ ఫ్రమ్ ద వర్కర్స్ పాయింట్ ఆఫ్ వ్యూ. ఈ మీన్స్ టెస్టెడ్ అదేంటో నాకు తెలియట్లా. మీన్స్ టెస్టెడ్ బెనిఫిట్స్ ఏంటి?
It is based on social security payments that are awarded based on an individual's family income and assets. అంటే లైక్ బిలో పావర్టీ ఉన్న వాళ్ళకి కొంచెం డిస్ట్రిబ్యూట్ చేయడము, లైక్ కరోనా టైంలో డిస్ట్రిబ్యూట్ చేశారు కదా, సో సిమిలర్ లైక్ దట్.
ఓకే.
These benefits are designed, means tested benefits are designed to provide a safety net for those with limited financial resources, ensuring they have access to basic necessities.
టర్మ్స్ చాలా క్లోజ్ గా ఉన్నాయి కదా. ఐ మీన్ వెరీ
Yeah, basically, ma'am, if మీరు ఇందాక you were talking about నాన్ కాంట్రిబ్యూటరీ కదా, మీన్స్ టెస్టెడ్ అంటే ఫర్ ఎగ్జాంపుల్ మా ఊర్లో సైక్లోన్ వచ్చింది. సైక్లోన్ వచ్చినప్పుడు ఏం చేస్తారంటే ఒక పూరిల్లు ఎగిరిపోయింది. సో మా డాబా మీద ఓన్లీ పార్ట్ ఆఫ్ ఇట్ ఈస్ ఎఫెక్టెడ్ బికాస్ ఆఫ్ ద సిమెంట్ థింగ్. సో బేస్డ్ ఆన్ యువర్ ఇన్కమ్ అండ్ అసెట్స్, ద గవర్నమెంట్ డిసైడ్స్, ఓకే వీడి ఇల్లంతా ఎగిరిపోయింది అండ్ హీఈస్ ఎ పూర్ గై, వీడికి 1,00,000 రూపాయలు ఇస్తాం, నీకు 10,000 ఇస్తాం, బికాస్ నీ ఇన్కమ్ అసెట్స్ ఎక్కువ ఉన్నాయి నీకు. దట్స్ వాట్ ఈస్ మీన్స్ టెస్టెడ్. It is determined based on your income and assets.
Okay, okay. Means tested benefits. Okay.
which is what
The
Pawan sir is.
Dan basis మీద it is divided. Benefits are divided. Okay.
ఎగ్జాక్ట్.
Okay.
ఇప్పుడు రిలీఫ్ ఫండ్ ఒక విలేజ్ కి ఓన్లీ ₹1,00,00,000 వచ్చాయి ఆర్ ₹1,00,000 వచ్చాయి.
Oh.
సో ఎక్కువ కాంపోనెంట్ వీళ్ళకి వెళ్తాయి, పూర్ పీపుల్ కి. తక్కువ కాంపోనెంట్ మిడిల్ క్లాస్ రిచ్ వాళ్ళకి వస్తాయి.
Oh, okay, okay, okay. That is means tested benefit.
మీన్స్ టెస్ట్.
Okay. Correct. So, in conclusion, social insurance is a vital tool for building a more secure and equitable and stable society by pooling reserve. Okay. Shall I read the cases?
Yeah. So
Relevant
important
cases.
అంటే ఈ లాస్ట్ పారాగ్రాఫ్ we can write in the first one also. సోషల్ ఇన్సూరెన్స్ కి సోషల్ సెక్యూరిటీకి తేడా ఏంటో.
Oh, yeah, we can write this.
Because
So, this is
90% of the
broader
people,
concept. Mm.
correct. 90% of the people సోషల్ ఇన్సూరెన్స్ రాగానే సోషల్ సెక్యూరిటీ రాసేస్తున్నారు.
Oh. Oh.
Yeah. Sorry. Go ahead with the cases.
Okay. Relevant cases are ESI Corporation versus Francis DeCosta. Supreme Court ruled that casual or temporary employees also fall under the purview of social insurance, like ESI, if they meet the minimum eligibility requirements. The ESI Act is a beneficial legislation and must be interpreted in a manner that is favorable to the workers, irrespective of the nature of their engagement. So, what is the key point here is social security is not dependent on the permanent nature of employment. Even casual workers deserve the coverage. Deserve this ESI. Okay, fine. Regional Director ESI Corporation versus Highland Coffee Works. The court held that the test of applicability of social insurance laws is whether employees are working in a factory or establishment under supervision and control, regardless of the payment method.
Okay. So the first case ఏంటంటే we have already studied the first case where in a lot of other contexts. If simple thing ఏంటంటే just go to this, if you're seeing the screen, just go here and then you'll say what if you see the Francis DeCosta, it is you've used it 6 times. So earlier cases, so basically broadly what it is talking about is ఈ ఏదైతే కాంట్రాక్ట్ వర్కర్స్ ఉంటారో వాళ్ళకి దే ట్రై టు అవాయిడ్ పేమెంట్స్. సో అది వాళ్ళు the Supreme Court దాకా వెళ్ళింది ఆ కేసు. And the Supreme Court said, no, you have to pay. That is a famous case which is quoted everywhere. I think we were discussing that case yesterday. ESI benefits అయితే ఇవ్వాల్సి వస్తుంది.
Okay. Casual, temporary, you have to give the benefits.
So in the second case is also the similar case where the court ఏమందంటే సోషల్ ఇన్సూరెన్స్ ఈ ఎంప్లాయీస్ ఈ హైలాండ్ కాఫీ వాళ్ళు చాలా స్మార్ట్ గా ఏం చేశారంటే అవుట్ సోర్స్ చేశారు వర్కర్స్. వేరే కంపెనీకి ఉన్నారు కదా సార్, ఆ కంపెనీని అడగండి, మమ్మల్ని అడగండి అన్నారు. ఇది కూడా సుప్రీం కోర్ట్ దాకా వెళ్ళింది. సో సుప్రీం కోర్ట్ సెడ్ ద టెస్ట్ ఆఫ్ అప్లికబిలిటీ ఆఫ్ సోషల్ ఇన్సూరెన్స్ లాస్ ఏంటంటే దే సెడ్ దట్ any employee who is working in a factory under the supervision and control, వాడు ఎక్కడ అవుట్ సోర్స్ ఏ కంపెనీ అయినా కానీ ఎవడి సూపర్విజన్ ఎవడి కంట్రోల్ కింద ఉన్నాడు, నీ కంట్రోల్ కింద ఉన్నాడు, దెన్ యూ హ్యావ్ టు పే ద ESI benefits for them.
Oh, okay. Under supervision control of that particular this one. Okay, establishment.
So this was a
Even
landmark.
if you outsource also, it doesn't really matter. They were working under you. Okay.
Correct. So this is like a landmark judgment which they gave. And this basically 1991 ఇచ్చారు. సో ఇది ఏంటంటే ఈ కేసుని కూడా చాలా చోట్ల కోట్ చేస్తారనమాట. సార్ నాకు ESI బెనిఫిట్స్ ఇవ్వట్లేదు, నేను ఈ కంపెనీ కానీ నేను వర్కింగ్ ఫర్ ఇండియన్ ఆయిల్ కానీ నేను ప్రైవేట్ నుంచి వచ్చాను అంటే దెన్ ద గవర్నమెంట్ అదే వీళ్ళు ఏమంటారు, ఇండియన్ ఆయిల్ వాళ్ళు నువ్వే ఇవ్వాలరా బాబు వాడికి ESI బేస్డ్ ఆన్ దిస్ జడ్జ్మెంట్. సో జడ్జెస్ ఆల్సో నీడ్ నాట్ వరీ కదా, ఎర్లియర్ ప్రెసిడెంట్స్ ఉన్నాయి కదా సుప్రీం కోర్ట్ జడ్జ్మెంట్స్, ఈ జడ్జి ఇది కోట్ చేసుకుంటే వాళ్ళు జడ్జ్మెంట్ ఇచ్చేస్తారు అనమాట.
ఓకే
అది అంతేనా మేడం? నిర్మలా మేడం క్లారిఫై చేయకపోతే కష్టం.
No, that's true. I was thinking of something else. మనకి first semester లో we read about vicarious liability కదా.
Vicarious liability. Yeah.
అది గుర్తొచ్చింది ఎందుకో. ఓకే, ఎనీవే గో హెడ్.
Vicarious
ఎందుకు
liability.
మేడం అది గుర్తొచ్చింది? ఆహా,
దాంట్లో
ఈ
ఎందుకు
మాస్టర్
గుర్తొచ్చిందంటే
మాస్టర్ సర్వెంట్
ఇండిపెండెంట్
రిలేషన్షిప్.
కాంట్రాక్టర్.
యా
ఇన్
యా.
ఇండిపెండెంట్ కాంట్రాక్టర్స్ ఒక కేసు ఉంది వేర్ విల్ దే ఫాల్ అండర్ దిస్ వైకేరియస్ లైబిలిటీ అని. బట్ ఇఫ్ ద ఇండిపెండెంట్ కాంట్రాక్టర్ is still working under the control of the principal or the master or something, the master will still be vicariously liable for the contractor's deeds. అదేదో గుర్తొచ్చింది, సమ్ లాంగ్ షార్ట్, లీవ్ ఇట్.
మీరు అక్కడ దాకా కనెక్ట్ చేస్తారు మేడం, అసలు గ్రేట్ మేడం మీరు. ఓకే, సో లెట్స్ గో ఫర్ ద 13 and 14 and finish it off. యా, నాకు ఆల్రెడీ నిద్ర వస్తుంది.
ఓకే, షల్ ఐ రీడ్ 13?
మేడం
ఇట్స్ ఓన్లీ చదువుతా కాదు, ఇట్స్ ఓన్లీ 10. వై ఆర్ యూ, నిద్ర ఎందుకు వస్తుంది మీకు?
లెఫ్టిస్ట్ అది కూడా కంట్రోల్ చేస్తారు మేడం. నా నిద్ర నా ఇష్టం మేడం, ఎప్పుడన్నా రావచ్చు.
10:30కే రావాలి మనకి పని అయిపోయినాక.
ఓకే ఓకే ఓకే, మీరు చదవండి పాపం. 2 క్వశ్చన్స్ చదివారు కదా, మీరు 2 చదివి క్లోజ్ చేసేయండి.
Okay, occupational diseases. What are occupational diseases? Occupational diseases are distinct from injuries sustained as a result of sudden accidents. Injuries, they come as sudden accidents. They are outcome, byproduct of sudden accidents. Occupational diseases are something that affect your health over a period of time by getting exposed to certain type of work over a period of time. You get occupational diseases. One famous example I can think of is people working in marble industry. They are more prone to silicosis. I mean, 90% of them have silicosis in their lungs. So those are occupational diseases. They are chronic diseases or chronic health conditions which have a direct connection with the work of the employee and the physical and chemical exposures to hazards in workplace conditions. Whereas an injury from an accident may occur without notice, an occupational disease usually develops over time as a result of exposure to physical, biochemical, biological, and ergonomic agents and conditions during one's employment, often being gradual in developing consequences. Occupational diseases can be recognized if there is a demonstrable connection between the employment and disease offerings. So this is occupational disease. The Employees Compensation Act 1923 and occupational diseases. So what is the relation between this act and occupational diseases? The act before compensation was available. The act before compensation was available to employees recognize the hidden or insidious nature of certain work-related health impairments. Act before compensation was available to employees. Basically, the act recognized for the first time the hidden and insidious nature of certain work-related health impairments. By including occupational diseases in the legislation, it has now established liability where an employee who has developed and suffers from an occupational disease can rely on receiving compensation from his or her employer under the Act, treating the occupational disease with equal legal rigor as if it was an accidental injury. Once you are able to establish that the disease you have acquired is based on the occupation, it can be treated as an accidental injury and then the same compensation will apply. This demonstrates a great deal of concern for workers going beyond immediate traumatic incidents to treatment for long-term health effects of dangerous employment. Important provisions. Schedule 3. A critical feature of the Act is its Schedule 3, which establishes an official list of specific occupational diseases. So Schedule 3 talks about the list of occupational diseases. Importantly, this schedule also sets out occupations or processes in which the occupational diseases listed in Schedule 3 have an accepted and identifiable relationship to someone who is employed in an occupation or employment process where the disease is a hazard. So vaadu aa particular setup lo employment lo undali. He should be employed in that, he or she should be employed in that particular setup. Thus, scheduling 3 allows the employee to discharge part of their evidential burden. సో నాకు దీని వల్ల వచ్చిందని ఎవిడెన్షియల్ బర్డెన్ పార్ట్ అక్కడే వెళ్ళిపోతుంది బికాస్ యూఆర్ బై డిఫాల్ట్ డిఫాక్ట్ యూఆర్ ఎంప్లాయిడ్ హియర్ therefore you are prone to that particular disease. So that part of evidential burden is taken care of. Next thing is deemed injury by accident. If an employee becomes ill with a disease that is listed in Schedule 3 and the employee has been employed in that occupation for an unbroken period of time as the regulations may specify for some diseases. అంటే 3 రోజుల్లో నాకు టీబీ వచ్చింది కాటన్ మిల్లో పనిచేసంటే అట్లా ఒప్పుకోరు. There should be a stipulated time period. You should be exposed to those working conditions. And then if you contact that particular disease, then it is occupational hazard. That is basically what they are saying. So, has been employed in that occupation for an unbroken period of time as the regulations may specify for some diseases, then that illness will be treated as an injury by accident occurring out of and in the course of their employment. This creates a potent legal fiction in favor of the employee as it largely absolves them from proving direct causation in every case as the presumptive burden is on the employer. Now, employer has to prove that ఇది కాదు వీడు తప్పు క్లెయిమ్ చేస్తున్నాడు, but the burden of proof is on the employer, not the employee, once this relationship is established. Third point is employer's strict liability. Once the scheduled occupational disease has been diagnosed, satisfying the Act's definition, the employer has strict liability to compensate the employee. The manner and method of establishing the compensation amount and the entitlement to compensation is largely the same as for accidental injuries under the Act, including wages and extent of disablement. So this will be treated as an accidental injury with respect to payment of wages and extent of disablement. And between the work and the disease is established. Next point is reporting obligations. Employers generally are required to report any diagnosed case of occupational diseases to the appropriate regulatory bodies. Supports data collection, epidemiology tests, and public health interventions. So employers are supposed to disclose that working here will cause. Amendment to Schedule 3. The nature of industrial activity, example, manufacturing, construction, mining, etc., is dynamic, and the medical awareness of hazards and risks related to workers' health can change and develop. Because of this, Schedule 3 should not be static. It should allow the relevant government to conduct regular amendments where occupational disease that have been uncovered can be added to ensure that the Act remains relevant and encompassing. For example, పూర్వకాలంలో this carpal tunnel syndrome ఇవన్నీ ఉండేవి కాదు. After computers have come, all these diseases have come up కదా. So this is what they are saying. Schedule 3 should be dynamic, so additions, modifications can be done. Examples of occupational diseases covered by the Act. Schedule 3 organizes diseases based primarily on industry and or form of exposure. There are several relevant occupational diseases such as pneumoconiosis, group of lung diseases, which is I talked about silicosis, silicosis, asbestosis, coal workers, pneumoconiosis, caused by inhalation of certain mineral dust prevalent in mining, quarrying, construction, and manufacturing. Second, lead poisoning.
Ma'am, my voice breaks.
Hearing loss. Gradual loss of hearing resulting from exposure to excessive levels of noise for sustained periods in difficult industrial environments. Occupational dermatitis. Skin diseases that occur from exposure to irritants and allergens in the workplace. So ఇవన్నీ different occupational diseases. దీంట్లో important thing computer related carpal tunnel syndrome రాయలేదు. This is outdated actually. రాయాలి అది కూడా. Importance of including occupational diseases. Including occupational diseases in the Act is paramount importance for comprehensive worker protection. Extending the benefit of the Act to workers extending the benefit of the Act to workers beyond immediate injuries to address longer term health deficits that are often slow and insidious in nature that are indirectly attributable to the work environment. So So that needs to be covered. Therefore, it's important. Incentive for prevention. By placing liability where it belongs to the employer, the Act creates an impetus for employers to identify, assess, and abate hazards which have a potential to become occupational health hazards. Fundamentally, it facilitates the workplace being safer and healthier. So వాడు ముందస్తు జాగ్రత్తలు తీసుకొని కొంచెం హెల్ప్ ఏదైనా మాస్క్లు అట్లాంటి ఏదైనా గేర్ ఇస్తే then he will also avoid this liability. Ani. Promotion of social justice. The legislation encapsulates the belief that the cost of industrial production in terms of how it affects worker magnitude of health should not be borne solely by the worker. It sits within the context of social security and social welfare. So this is broadly the concept of occupational diseases and on the employer. Now, relevant cases, ఇది చదివాము, మీరు 2 కేసులు చదివాము, but I will whip through. Regional Director, ESI Corporation versus Francis DeCosta. Although the case primarily relates to Employee State Insurance Act, arguably the Supreme Court of India has captured the Social Security legislations must be read harmoniously and should include the Employees Compensation Act. అని చెప్పింది. The Supreme Court went on to note that where a disease could be attributed entirely to the working conditions, and particularly a listed or recognized occupational disease, the worker would be entitled to claim compensation. This case is important for its emphasis that in the case of a listed disease, it could be presumed that the work connection was in favor of the employee, and therefore the burden of proof regarding causal connection to employment would be markedly lower. So it is tilted in the favor of the employee once this is proved. So this case apparently has multi dimensions. So one can quote in several concepts. McKinnon McKenzie and Company Private Limited versus Ibrahim Mohammed Isaac. The case stands out as one of the most important as it provides relevant elucidation and important interpretative meaning of the wording arising out of and in the course of employment. It's arising from being in employment and during the course of employment, which is one type of basis to establish an entitlement to compensation under the Act for both accidents and deemed occupational diseases. The Supreme Court affirmed the necessity where liability exists in case of an injury or disease, there must be a causal link between workers' employment, any activity in connection with that employment, and the injury or disease. The Supreme Court held a liberal interpretation is preferable and lean towards the worker, but constrained the duty owing to the worker to include activities directly related to becoming injured, incidental to the extent of employment. అంటే అంతవరకు అయితే worker has the duty to prove that it is from the employment అని. Concluding to extend liability recklessly is an evident breach of employment contract, and the worker's work-related activity at the time of becoming injured or deceased must occur if becoming injured is an incidental activity. Oh God, this is such a compound sentence. I think we need to break it. I think మీరు verbatim రాసేసినట్టున్నారు Supreme Court language. But constrained the duty owing to the worker. So the worker owes a duty to prove that it is coming directly from the activities associated with the occupation to the extent of employment. Concluding to extend liability recklessly is an evident breach of employment contract, and the worker's work-related activity at the time of becoming injured or deceased must occur if becoming injured is an incidental activity subsequent to the worker being retained as a worker.
ఇది యాక్చువల్గా ప్రొఫెసర్ మేడం రాసింది మేడం, ఇది నేను రాయలేదు.
Above my head.
Basically,
anyway, what I can do, చెప్పండి.
What it is saying is arising out and in of course of employment define చేస్తుంది. And that ఈ 2 కేసులు ఆక్యుపేషనల్ డిసీజ్ డైరెక్ట్ గా రిలేటెడ్ కాదు, ఇండైరెక్ట్ గా రిలేటెడ్.
Correct. But it is saying it has to extend to that.
ఎగ్జాక్ట్లీ. సో ఆక్యుపేషనల్ డిసీజ్ అన్నప్పుడు ఆ క్యాజువల్ లింక్ బిట్వీన్ ద వర్కర్స్ ఎంప్లాయ్మెంట్, ఎంత టైం వర్క్ చేశారు, అసలు ఆ వర్కింగ్ లో ఆ పనిలో ఆ డిసీజ్ వాళ్ళు తీసుకోగలరా ఆర్ ఇంజ్యూర్ అయ్యే ఛాన్సెస్ ఉందా, దానికి గైడ్ లైన్స్ ఇచ్చారు.
ఓకే.
అదే
Oh,
మేడం
that is
హెవీ
it.
ఇంగ్లీష్.
అదేముందిలే, we
English.
can break it down and write.
Yeah, yeah.
అది verbatim, I think she wrote, I mean, so court's language is always very compound and
Yeah.
complicated. So she wrote verbatim. That's okay. We can break that down into smaller, understandable sentences. But రేపు చేద్దాం ఆ 14th question. You should be happy about it.
Yeah, okay.
Yeah, I can understand that. So రేపు we will finish 14th through 20th.
40 questions ఉన్నాయి. So,
20th దాకా finish చేద్దాం రేపు.
ఈ వీక్ లో అవగొట్టేద్దాం దీన్ని.
Yes, labor law done.
లేబర్ లో అయిపోతే we can go to the next one. అండ్ ఇది మళ్ళీ పొద్దున్నే ఈ వీడియో మళ్ళీ ఇది ఎడిట్ చేయాలి. ఎడిట్ చేసి మళ్ళీ నేను పంపిస్తాను. మీ మెడికల్ ఇవన్నీ తీసేసి ఎడిట్ చేసి పంపిస్తాను.
కాదు నేను ఏమంటున్నా, పార్ట్ ఏ అయిపోయినాక ఇంకా పార్ట్ సి ఇప్పుడు చేయము. వి విల్ డూ లిటిల్ లేటర్ కదా పార్ట్ సి కదా.
పార్ట్ సి నన్ను అడిగితే ఒకటి చేసేద్దాం మేడం, ఎందుకంటే జస్ట్ 1.5 hour పడుతుంది. ఎగ్జామ్ ముందు కూడా 1.5 hour తీసుకుంటున్నాం కదా. ఒక సబ్జెక్ట్ అయిపోయినట్టు ఉంటుంది, మళ్ళీ అప్పుడు రివిజన్ చేసుకోవచ్చు.
Done. That's a good idea too. Okay, then we'll call it a day today, and tomorrow we'll finish till 20th. Everyone okay with that?
Yeah. Thank you, Pawan sir. Thank you.